I have a copy of it. It was filed with the clerks, and they gave me the copy. But before we continue, I want Mr. Bradley to be in the courtroom. Okay, Mr. Moore, you're requesting that the instruction with regard to psychotropic medication, that be read as well?
Yes, ma'am, I am. I think a reasonable place to put it would be after reasonable doubt instruction. 3.7.
Okay, well, with all due respect, do you want me, I mean, I have 15 packets prepared with staples in them. Do you want, and I can't give it to them like this, so it'd have to be prepared in a different way. Do you want me to just read it and tell them that it's not part of their packet, or do you want to?
Please do. That's fine.
Okay. If you want me to take a few moments, we can redo it, but.
Read it. Tell them it's not part of their packet, but it goes along.
Okay, I'll tell them that. Response from the state.
Judge, I mean, it's appropriate to read it. Maybe read it right in the beginning. We're not giving it to the packet. I don't know if we want to insert it in the order of your reading somewhere in the middle. So I'll leave that up to you.
You know, I could do it first thing. I could just read it first thing.
That's fine.
Okay. Okay, any other matters on behalf of the state?
Judge, we're going to check. I know the family's not back yet.
They said they're on their way up.
Okay.
Anything else?
Okay.
Anything else on behalf of the defense?
No, Your Honor.
I just saw a lot of movement. I was going to give them a moment. Your mic's off. Hold on. Okay, we can go ahead and bring the jury into the courtroom. If you guys could avoid talking on these things while I do that.
Yes, ma'am.
This is the only thing that will get me. This is the only time that bothers me is when I'm reading jury instructions. They're not allowed to type either, so.
When she starts jury instructions, we would ask them not to get up and leave. If they do leave, please don't come back in. Make sure your cell phones are vibrated off, please.
Jury's present. All rise.
Please be seated. Good afternoon, ladies and gentlemen of the jury. Has anyone read or been exposed to reading newspaper headlines and/or articles relating to this trial or its participants? Has anyone seen or heard television, radio, or internet comments about this trial? Have you read any news headlines or articles relating to this trial or its participants? Has anyone conducted or been exposed to any research regarding any matters concerning this case? And have you discussed this case among yourselves or with anyone else, or allowed anyone to discuss it in your presence? Ladies and gentlemen, Brandon Lee Bradley currently is being administered psychotropic medication under medical supervision for a mental or emotional condition. Psychotropic medication is any drug or compound affecting the mind or behavior, intellectual functions, perception, moods, or emotion, and includes psychotic, antidepressant, anti-manic, and anti-anxiety drugs. We will now proceed to final instructions. To assist you in following the law as I instruct you, the instructions have been reduced to writing. A copy of the written instructions, we do have a copy of the written instructions for each of you. Also, you may take these instructions with you to the jury room for use during your deliberations. You may write on them. After you deliberate and return your verdict, I will need all of your jury instruction packets back. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give. Statement of charge. Brandon Lee Bradley, the defendant in this case, has been accused of the crimes of count 1, first-degree murder of a law enforcement officer with a firearm. Count 2, robbery. Count 3, fleeing or attempting to elude a law enforcement officer, siren and lights activated, with high speed or reckless driving. Count 4, resisting an officer with violence. Introduction to homicide. In this case, Brandon Lee Bradley is accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree, murder in the third degree, and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Barbara Pill was killed by Brandon Lee Bradley, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was murder in the second degree murder, or in the third-degree manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any vehicle in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden or sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Brandon Lee Bradley may be found guilty of first-degree murder or any lesser included crime. Murder first degree. There are two ways in which a person may be convicted of first-degree murder. One is known as premeditated murder. The other is known as felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, Barbara Pill is dead. Number 2, the death was caused by the criminal act of Brandon Lee Bradley. Number 3, there was a premeditated killing of Barbara Pill. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time which must pass between the formation of the premeditated intent to kill and the killings. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. A question, or the question of premeditation, is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If a person has a premeditated design to kill one person, and in attempting to kill that person actually kills another person, the killing is premeditated. Felony murder first degree. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, Barbara Pill is dead. Number 2, the death occurred as a consequence of and while Brandon Lee Bradley was escaping from the immediate scene of a robbery. Number 3, Brandon Lee Bradley was the person who actually killed Barbara Pill. In order to convict of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. Robbery. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. Number 1, Brandon Lee Bradley took the property from the person or custody of Andrew Jordan Mohammed Malik. 2, force, violence, assault, or putting fear was used in the course of the taking. Number 3, the property taken was of some value. Number 4, the taking was with the intent to permanently or temporarily deprive Andrew Jordan Mohammed Malik of his right to the property or any benefit from it, or to appropriate the property of Andrew Jordan Mohammed Malik to his own use or to the use of any person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the victim making the threat has the ability to carry out the threat.
Your Honor,
Yes.
the person making the threat.
What did I say? I'm sorry about that. I'll read that paragraph again. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of the victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then the victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitutes continuous series of acts or events. If you find that the taking of the property occurred as an afterthought to the use of force or violence against the victim, the taking does not constitute robbery, but may still constitute threat. In order for a taking of property to be robbery, it is not necessary that the person robbed be the actual owner of the property. It is sufficient if the victim has the custody of the property at the time of the offense. The taking must be by the use of force or violence or by assault so as to overcome the resistance of the victim, or by putting the victim in fear so that he does not resist. The law does not require that the victim of robbery resist to any particular extent, or that the victim offer any actual physical resistance if the circumstances are such that the victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of the victim. It is sufficient if the property taken is under the actual control of the victim, so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. Fleeing to elude a law enforcement officer, siren and lights activated with high speed or reckless driving. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Brandon Lee Bradley was operating a motor vehicle upon a street or highway in Florida. Number 2, Brandon Lee Bradley, knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. Number 3, the law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle and with siren and lights activated. Number 4, during the course of the fleeing or the attempt to elude, Brandon Lee Bradley drove at high speed or in any manner demonstrating a wanton disregard for the safety of persons or property. Operating means any person who is in actual physical control of a motor vehicle upon the highway. Street or highway means the entire width between boundary lines of every way or place of whatever nature when any part thereof is open to the public for the purpose of vehicular traffic. Vehicle means any device in, upon, or by which any person or property is or may be transported or drawn upon a highway, excepting devices used exclusively upon stationary rails or tracks. Willfully means intentionally, knowingly, and purposely. Resisting officer with violence. To prove the crime of resisting officer with violence, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Brandon Lee Bradley knowingly and willfully resisted, obstructed, or opposed Deputy Barbara Pill by offering to or doing violence to her. Number 2, at the time Deputy Barbara Pill was engaged in the lawful execution of a legal duty. Number 3, at the time Barbara Pill was an officer. Number 4, at the time Brandon Bradley knew Barbara Pill was an officer. The court now instructs you that every Brevard County Sheriff's Office deputy is an officer within the meaning of this law. Offering to do violence means threatening to do violence. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts which would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of count 1, first-degree murder, are second-degree murder, third-degree felony murder, manslaughter. The lesser crimes included in the definition of count 2, robbery, are grand theft, theft, assault. The lesser crime indicated in the definition of count 3, fleeing or attempting to elude a law enforcement officer, siren and lights activated with high speed or reckless driving, are fleeing to elude a law enforcement officer with lights and sirens, fleeing to elude a law enforcement officer. The lesser crime indicated in the definition of count 4, resisting an officer with violence, is resisting an officer without violence. Murder second degree. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Barbara Pill is dead. Number 2, the death was caused by the criminal act of Brandon Lee Bradley. Number 3, there was an unlawful killing of Barbara Pill by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm or serious bodily injury to another, and 2, is done for ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Felony murder, third degree. To prove the crime of third-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Barbara Pill is dead. Number 2A, the death occurred as a consequence of and while Brandon Lee Bradley was engaged in the commission of grand theft, or B, the death occurred as a consequence of and while Brandon Lee Bradley was escaping from the immediate scene of grand theft. 3, Brandon Lee Bradley was the person who actually killed Barbara Pill. It is not necessary for the state to prove the killing was perpetrated with a design to effect death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Barbara Pill is dead. Number 2A, Brandon Lee Bradley intentionally committed an act or acts that caused the death of Barbara Pill, or B, Brandon Lee Bradley intentionally procured an act that caused the death of Barbara Pill, or C, the death of Barbara Pill was caused by the culpable negligence of Brandon Lee Bradley. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, the violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard of the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. If you find the defendant guilty of manslaughter, you must then determine whether the state has further proved beyond a reasonable doubt that Barbara Pill was at the time an officer who was at the time performing duties that were within the course of her employment. The court now instructs you that a deputy with the Brevard County Sheriff's Office is an officer. Dangerous weapon is any weapon that, taking into account the manner in which it was used, is likely to produce great death or great bodily harm. Officer means any person employed or appointed as a full-time, part-time, or auxiliary law enforcement officer, correctional officer, or correctional probation officer. Possession of a firearm with discharge causing death. If you find that Brandon Lee Bradley committed first-degree murder, or any lesser included offense of such crime, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm and in doing so caused the death of Deputy Barbara Pill, you should find the defendant guilty of such crime with discharge of a firearm causing death. If you find that Brandon Lee Bradley committed first-degree murder or any lesser included offense of such crime, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of such crime with discharge of a firearm. If you find that Brandon Lee Bradley committed first-degree murder or any lesser included offense of such crime, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of such crime with actual possession of a firearm. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer or destructive device or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm, the defendant A, carries a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Theft. To prove the crime of theft, the state must prove the following two elements beyond a reasonable doubt. Number one, Brandon Lee Bradley knowingly and unlawfully obtained or used or endeavored to obtain or use the property of Andrew Jordan Mohammed Malik. Two, he did so with intent to, either temporarily or permanently, A, deprive Andrew Jordan Mohammed Malik of his right to the property or any benefit from it, or B, appropriate the property of Andrew Jordan Mohammed Malik to his own use or to the use of any person not entitled to it. If you find the defendant guilty of theft, you must also determine if the state has proved beyond a reasonable doubt whether the value of the property taken was $300 or more. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control over property. Endeavor means to attempt or try. Property means anything of value. Value means the market value of the property at the time and the place of the offense, or if that value cannot be satisfactorily ascertained, the cost of replacement of the property within a reasonable time after the offense. If the exact value of the property cannot be ascertained or ascertained, you should attempt to determine a minimum value. If you cannot determine the minimum value, you should find the value is less than $300. Amounts of value of separate properties involved in thefts committed pursuant to one scheme or course of conduct, whether the thefts are from the same person or several persons, may be added together to determine the total value of the theft. Fleeing to elude a law enforcement officer, siren and lights activated. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following three elements beyond a reasonable doubt. Number one, Brandon Lee Bradley was operating a motor vehicle upon a street or highway in Florida. Number two, Brandon Lee Bradley knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. Number 3, the law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings predominantly displayed on the vehicle and with siren and lights activated. Operating means any person who is in actual physical control of a motor vehicle upon the highway. Street or highway means the entire width between boundary lines of every way or place of whatever nature when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means any device in, upon, or by which any person or property is or may be transported or drawn upon a highway, excepting devices used exclusively upon stationary rails or tracks. Willfully means intentionally, knowingly, and purposely. Fleeing to elude a law enforcement officer. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Brandon Lee Bradley was operating a motor vehicle upon a street or highway in Florida. Number 2, a duly authorized law enforcement officer ordered the defendant to stop or remain stopped. Number 3, Brandon Lee Bradley, knowing he had been ordered to stop by a duly authorized law enforcement officer, A, willfully refused or failed to stop the vehicle in compliance with the order, or B, having stopped the vehicle, willfully fled in a vehicle in an attempt to elude a law enforcement officer. Operating means any person who is in actual physical control of a motor vehicle upon the highway. Street or highway means the entire width between boundary lines of every way or place of whatever nature when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means any device in, upon, or by which any person or property is or may be transported or drawn upon a highway, excepting devices used exclusively upon stationary rails and tracks. Willfully means intentionally, knowingly, and purposely. Resisting officer without violence. To prove the crime of resisting officer without violence, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Brandon Lee Bradley resisted, obstructed, or opposed. Number 2, at the time, Barbara Pill was engaged in the lawful execution of a legal duty. Number 3, at the time, Barbara Pill was an officer. Number 4, at the time, Brandon Lee Bradley knew Barbara Pill was an officer. The court now instructs you that every deputy with the Brevard County Sheriff's Office is an officer within the meaning of this law. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if, 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. Voluntary intoxication. Voluntary intoxication resulting from the use of a controlled substance is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he knowingly consumed a substance that he knew or should have known could cause intoxication. Mental condition. Evidence of any abnormal mental condition is not a defense to any crime. Evidence of a defendant's abnormal mental condition may not be taken into consideration to show that he lacked the specific intent to commit any crime. Such evidence is to be considered by you only for the purposes of determining whether the defendant's interview was knowingly, voluntarily, and freely made. Justifiable use of deadly weapon. An issue in this case is whether the defendant acted in self-defense. It is a defense to the offense with which Brandon Lee Bradley is charged if the death of Barbara Pill resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable only if the defendant reasonably believed that the force is necessary to prevent imminent death or great bodily harm to himself while resisting 1. Another's attempt to murder him, or 2. Any attempt to commit robbery upon him, or 3. Any attempt to commit robbery upon or in any vehicle occupied by him. A person is justified to use deadly force if he reasonably believed that such force is necessary to prevent 1. Imminent death or great bodily harm to himself or another, or 2. The imminent commission of robbery against him or another. However, the use of deadly force is not justifiable if you find Brandon Lee Bradley was attempting to committing, or escaping after the commission of a robbery. A person is not justified in using force to resist an arrest by a law enforcement officer, or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. In deciding whether defendant was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, the defendant must have actually believed that the danger was real. If the defendant was engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or to prevent the commission of a forcible felony. A forcible felony is any degree of murder, manslaughter, aggravated battery, aggravated assault, or shooting into an occupied vehicle. If the defendant was in an occupied vehicle where he had a right to be, he is presumed to have had a reasonable fear of imminent death or great bodily harm to himself if Barbara Pill had unlawfully and forcibly entered, removed, or attempted to remove another person against that person's will from that dwelling, residence, or occupied vehicle, and the defendant had reason to believe that had occurred. The defendant had no duty to retreat under such circumstances. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person who uses defensive force is engaged in an unlawful activity or is using the occupied vehicle to further an unlawful activity, or B, the person against whom the defensive force is used is a law enforcement officer who enters or attempts to enter a vehicle in the performance of her official duties and the officer identified herself in accordance with any applicable law, or the person using the force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer. A person who unlawfully and by force enters or attempts to enter another's occupied vehicle is presumed to be doing so with the intent to commit an unlawful act involving force or violence. As used with regard to self-defense, vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport people or property. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of the defendant and Barbara Pill. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether the defendant was justified in the use of deadly force, you should find the defendant not guilty. However, if from the evidence you are convinced that the defendant was not justified in the use of deadly force, you should find him guilty if all the elements of the crime have been proved. Plea of guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other evidence and does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 9, has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered. but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case, may have reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to prove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statement. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain it was knowingly, voluntarily, and freely made. Therefore, you must consider from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not knowingly, voluntarily, and freely made, you should disregard it. Eyewitness identification. You have heard testimony of eyewitness identification. In determining how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to those factors, in evaluating eyewitness identification testimony, you may also consider: 1, the capacity and opportunity of the witnesses to observe the offender based upon the length of time for observation and the conditions at the time of the observation, including lighting and distance. 2, whether the identification was the product of the eyewitness's own recollection or was the result of influence or suggestiveness. 3, the circumstances under which the defendant was presented to the eyewitness for identification. 4, any inconsistent identifications made by the witness. 5, any instance in which the witness did not make an identification when given the opportunity to do so. 6, the witness's familiarity with the subject identified. 7, lapse of time between the event and the identifications. 8, whether the eyewitness and the offender are of different races or ethnic groups, and whether this may have affected the accuracy of the identification. 9, the totality of the circumstances surrounding the eyewitness's identification. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, the jury is not to discuss any question that a juror wrote that was not answered by the court and must not hold that against either party. 8, each verdict should not be influenced, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Cautionary instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged in the information or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proved beyond a reasonable doubt. If you find that no offense has been proved beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary forms of verdicts have been prepared for you. They are as follows. Now, there are verdict forms. They are not in your packet. I only have one set of these, and they will be given to you at the time that you deliberate, but I am going to read them. Verdict. We, the jury, find as follows as to count 1, as to the defendant in this case, check only 1. A, the defendant is guilty of first-degree murder. B, the defendant is guilty of second-degree murder. C, the defendant is guilty of third-degree felony murder. D, the defendant is guilty of manslaughter. E, the defendant is not guilty. Special interrogatories. If you find the defendant guilty of any offense above, you must answer the following. A, did the defendant, Brandon Lee Bradley, actually possess a firearm during the commission of the offense? Yes, no. B, if yes to A, did the defendant, Brandon Lee Bradley, discharge a firearm during the commission of the offense? Yes, no. C, if yes to B, did the defendant, Brandon Lee Bradley, cause death as a result of discharging a firearm during the commission of the offense? Yes, no. D, was Barbara Pill a law enforcement officer? Yes, no. So say we all this blank day of blank, 2014 in Viera, Brevard County, Florida, and it's signed by the foreperson. Okay, verdict. We, the jury, finds as follows as to count 2, the defendant in this case. Check only 1. A, the defendant Brandon Lee Bradley is guilty of robbery. B, the defendant Brandon Lee Bradley is guilty of grand theft. C, the defendant Brandon Lee Bradley is guilty of theft. D, the defendant Brandon Lee Bradley is guilty of assault. E, the defendant Brandon Lee Bradley is not guilty. So say we all this blank day of blank, 2014 in Viera, Brevard County, Florida, signed by the foreperson. Verdict. We, the jury, find as follows as to count 3, the defendant in this case. Check only 1. A, the defendant, Brandon Lee Bradley, is guilty of fleeing or attempting to elude a law enforcement officer, siren and lights activated with high speed or reckless driving. B, the defendant, Brandon Lee Bradley, is guilty of fleeing to elude a law enforcement officer with lights and sirens. C, the defendant, Brandon Lee Bradley, is not guilty. Fleeing to elude a law enforcement officer. D, the defendant, Brandon Lee Bradley, is not guilty. So say we all this blank day of blank, 2014 in Viera, Brevard County, Florida, signed by the foreperson. Verdict. We, the jury, find as follows as to count 4, the defendant in this case. Check only 1. A, the defendant, Brandon Lee Bradley, is guilty of resisting an officer with violence. B, the defendant, Brandon Lee Bradley, is guilty of resisting officer without violence. C, the defendant, Brandon Lee Bradley, is not guilty. So say we all this blank day of blank, 2014 in Viera, Brevard County, Florida, signed by the foreperson. Okay, single defendant, multiple counts or informations. A separate crime is charged in each count, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. Now, just so you know, when you sign this form, you should sign it with your number and not your name. Okay, during deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy signed by the foreperson. And that would also mean number. Sign your number. If you have questions, we will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. Your verdict finding the defendant either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate, except for the firearm and live ammunition. If you wish to see those exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the law, even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Okay, if I could have a bench conference, please. Okay. At this time, I'm speaking to each individual juror. Is there any reason you as a juror are unable to continue to provide your services at this time? I know, anyone have any issues with continuing to provide their service at this time? If you do, if you'll raise your hand. Okay, I see no hands. I know that each one of you would make an outstanding contribution during the deliberation process, and I know that all of you have been very attentive. Under our Constitution, though, no more than 12 and no less than 12 are allowed to render this unanimous verdict. That means that number 190, 198, and 136, you have been chosen as alternates. It is the duty of the court to release you from deliberations in the guilt phase of this trial. Because of the order in which your names were drawn, you have been seated as alternate jurors. It was necessary that we have you serve in case one of the jurors was unable to complete his or her service. Fortunately, the jurors chosen prior to you have all been able to complete the trial. So I cannot allow you to actually participate at this time during the jury deliberation process. However, I do not know if there is going to be another phase to this trial, as we discussed during our jury selection. So what I'm going to do at this time is to excuse you. But I have to remind you that you are still under the order of this court not to have any discussions with anyone concerning this case, not to read or listen to any reports about this case, because if the second phase is necessary, I will be asking you to return to participate in the second phase of the trial. Now, at this time, we do not know the schedule for that. If there is a second phase, I anticipate that will commence shortly. I'm going to ask that you make sure that your telephone numbers are current with the jury clerk. If the number that you put on your jury questionnaire is incorrect, or if there is a number you would prefer to be contacted by, please let the jury clerk know that before leaving today. As soon as we know if there is a second phase, as soon as we know if a second phase is going to be necessary or not, we will contact you by the number that you have provided to us. And just so you know, you will be contacted one way or another. But again, I remind you that you remain under the order of the court. You cannot discuss this case with anyone, and you cannot read or listen to any reports about the case. No one is allowed to contact you concerning this case. At this time, I do want to thank you very much for your service. I am happy that the 12 jurors that were chosen before you are healthy and are able to participate. What I'm going to have you do is when I discharge the jury, I'm going to have you remain in your seats, and then we'll take you out separately after the other 12 are discharged. We will need to collect, to hold on to your notes, we will need to collect your notes, and they will be stored at this point. And if there is a second phase to this trial, you will get those notes back. If there is not a second phase to this trial, your notes will be destroyed unread. Okay, for the other 12 remaining jurors, in just a few moments you will be released to deliberate. The exhibits and verdict forms will be sent back shortly after you enter the room. As soon as the verdict forms are signed, push the button on the wall and it will advise the court deputy that you need him. He will see to it that all court personnel are present before he returns you to the courtroom. Let the record reflect that the defendant was present at all times during all phases of this trial. Now, ladies and gentlemen of the jury, you may retire now to deliberate your verdict. We will stand in recess and await the call of the jury.
All rise.
Okay, please be seated. Okay, at this time, I want the attorneys, if they'll review the exhibits and the verdict forms to make sure that all's proper before they're sent back to the jury room. I do want to compliment the attorneys for the proficient and professional manner in which this case was handled. It's very much appreciated by the court, and I appreciate it very much. Okay, we're going to stand in recess and await the call of the jury. I'll remain here until you tell me that everything's in proper form, and then at that time, we'll send the exhibits and the verdict forms back into the jury deliberation room, and I'll wait until that time. Okay, so we'll be in recess until we hear from the jury. Thank you. No, I can't. Okay. If you put their little packets in inside their envelope, they might want those for later.